wanted to welcome you today. My name is Brenda Agnew, and I am with an organization called 3 to Be. 3 to Be is a foundation that supports children with neurological disorders and their families in the areas of education, research, and therapies. My role within the organization is the director of our parent advocacy program, otherwise known as PAL. So joining me today is Neil, a partner from Howie Saxon Henry's, and also Megan, an associate with Howie Saxon Henry.
Thanks, Brenda. It's great to be here.
No problem at all. Thank you for being here. Today we're going to talk a little bit about, what if something just isn't right with your child, and has something happened perhaps before, during, or after the birthing process. And with that, let's begin. So one of the questions that I wanted to sort of bring forward to start this off would be, as a child, as a parent of a child with special needs, you know that something's not quite right about your child. What would be some red flags that parents might be looking for if there's something nagging in the back of their head about their child?
Yeah, that's a good question. Just at the beginning, if your child has actually been diagnosed with a neurologic disorder, then that's obviously a huge red flag. Then you know that there's something very serious going on that you want to look into and follow up on. But even if there hasn't been a serious diagnosis, if your child was treated in the NICU, in the neonatal intensive care unit, if your child seems to be not progressing or developing appropriately, if you just have an intuition or something in the back of your mind, if you have older children and other children that you've seen at that age, infants, and you sort of have just a sense that your child isn't developing and progressing in the way that you would have expected, then obviously you'll be following up with your doctor, your pediatrician, and trying to get the answers, trying to get testing and investigations done and answers. And as you go through that process, you may discover information that may give rise to some questions that you want to have checked out or discussed, in terms of whether there's any legal aspects that should be pursued in terms of the quality of the care that was given to your baby.
So while they're doing this investigation, they think that something's not quite right. They go back to their pediatrician, or they go back to whoever's been assessing their child. What types of questions would a parent maybe be looking for? You suggested some additional testing, or should they be trying to get some more detail around what might have actually transpired during maybe the birthing process, or more detail around their diagnosis? Like, should parents be kind of trying to gather some of that information?
I think so. And in terms of what happened around the birthing process, I think that family doctors and pediatricians will usually try to be quite helpful, and they'll get some of the records themselves if they can and try to help explain it to you as parents as to what took place, just to give you the insight into what happened. You can also try to talk about it with the obstetrician who was involved, or some of the other birthing staff in the hospital. But you may find that the conversation or your questions are not answered to your satisfaction, which is understandable because it's a sensitive issue.
Sure.
and there may be some people who get their guard up or get their back up over some of these questions. But those are the areas that you should be pursuing. First and foremost, obviously, your child's health and getting the best care that you can get going forward for your child. But in terms of trying to find out what happened, what had taken place, talk to your family doctor, who could be helpful, and have a meeting with the obstetrician.
So they've, let's assume that, this parent has, again, taking a similar situation. If I was in that situation and I had a child and I had this suspicion, and, I've asked these questions, and I've, sort of had an inkling that something may have transpired that, I'm not okay with, or, I have some concern around. What would be sort of some of the next steps? Should I be going to, ask for medical records? Is there things that I should be sort of gathering in preparation of sort of that next step, and what would that next step maybe look like?
Well, if you feel that the situation should be looked into and investigated further, then getting the medical records is the next step, and that is the next important step. It's an essential step, and every patient is entitled to a copy of their medical records. Your child is the patient.
Okay.
There is a hospital chart in your child's name, but you as the parent are allowed to obtain it.
Okay.
And there's also a chart at the hospital for yourself as the mother who gave birth to the child. So there'll be 2 separate charts at the hospital.
Okay.
And every patient at law in Ontario, in Canada, is entitled to a copy of their medical records without question. You don't even have to give a reason or an explanation. You're just entitled to a copy. You may have to pay a service fee or a photocopying fee to get it, but you can get it through the records department at the hospital, and that's usually the fastest way to get it.
Okay.
We will request those records ourselves as lawyers, but it actually comes a little later to us. It takes longer to come to the lawyer's office than to a patient who actually goes there themselves to get it.
So would you, suggest then to a parent before they might be thinking about calling a lawyer or contacting a lawyer to try to arm themselves with as much information? Does that help you when a parent walks through your door or makes a phone call for them to have as much information as possible?
Yeah, that definitely helps us, and then we're just that much further ahead when we start talking to you, and we can talk to you with a little bit more information. But some families and some parents aren't prepared or comfortable to take those steps initially, and they just want to have a first conversation with the lawyer, a preliminary conversation, and that's perfectly okay. We're happy to speak to you at that stage, and if you want us to then go out and get the records, we're perfectly happy to do that ourselves also.
Great. Well, I know that there may be some parents that are a little bit hesitant, right? Their child's being treated at a hospital. It could be where the pediatrician is. It could be where they've had other children. It could be, there's always, I think, a little bit of, uncertainty around how much they should be pushing. Is that going to affect the care that their child is currently getting at that treatment center or at that hospital? Or so I can see where some of the hesitation might be for a parent to want to, push the envelope a little bit. So if they're comfortable, then that's okay. If they're not, then that could be something that you could do sort of later on.
Yeah, exactly.
I think one of the important things to remember, and especially during these initial stages, when parents are educating themselves, when they're asking those tough questions, is this, what am I doing in terms of the care that they're now receiving? Because if anybody takes offense, if anybody stops giving optimal care because they learn that I am asking these questions and doing these investigations. But I think the important thing to remember is not only that you have a right to these records and you don't have to explain why you're getting them, but also because a lot can be told by the records quite quickly, and you want to ensure that the records are preserved. But the other thing is to keep in mind that if your child has been diagnosed with a neurologic disorder or has other signs that something might not quite be right, your interest as a parent is long-term. The interest of a medical team is often short-term treatment while they're in the NICU, while they're still, under the care of that particular OB or a specialist. And so it's important, I think, just to encourage parents to understand or to ensure that they understand from our perspective that what we would be looking at or what we'd be talking to the parents about is a long-term view of needs, of care, as opposed to a short-term concern about treatment at that time. But, and I don't know, Neil, about you in terms of your perspective of this, but I've never found that the quality of care has been affected by, asking those initial questions, by requesting those initial records. There is an understanding that people want to know more about what's going on, and so it's rarely an issue.
Okay. So one of the parent now has this child who may or may not have received a diagnosis. Sometimes they receive a diagnosis quickly, early on. Sometimes they receive a diagnosis later. There's definitely something that's not right. There's been some red flags. They've done some investigation. When is the right time to go ahead to look at pursuing a potential legal action? They've got a lot on their plate. There's a lot happening. Some parents think that they have a time frame. They have until 2 years to get this done. What would be something that you might want to say to that?
Well, the only situation where there's really a 2-year deadline to start a lawsuit is in the situation where your child has passed away. If your child has died and you're contemplating what's called a wrongful death claim, then the limitation period in Ontario at this time is 2 years from the date of death. In other words, you have to file a lawsuit within that 2-year period, or else the family loses its rights completely and permanently.
Okay.
But otherwise, there is a much longer period of time to file a lawsuit. And the case can be investigated early on or later, even years later. The records are kept on a long-term basis by hospitals and doctors. Generally speaking, the earlier you start to investigate, the better, because it's fresh in everyone's mind, and medical standards and medical knowledge is current and hasn't changed in any way yet. So it's generally good to start soon, but you can start much later. You can wait until you get a diagnosis. It can even be started up years after the fact.
So we've gotten to the point now then, parents think something's not up, or the child's, not right. The child's been given a diagnosis, maybe formally or, informally. Again, it could just be sort of hanging around there. They've gathered up their information. They've asked their questions. Sort of that point now where they want to talk to a lawyer. So, what's involved with that? That could be very scary for some people. It's an unknown. They've just gone through this sort of traumatic experience, or they're, in a bit of a fragile state. So, how do they start to pursue that conversation?
Well, usually, at least in our office, the initial conversation is by phone. So there's no pressure, no face-to-face initially. A lot of how we, have come to approach these types of questions or cases or conversations is with patience, with compassion, with understanding that it's not an easy initial phone call to make for a lot of people. There's sometimes people want answers, and sometimes people are really concerned about what that answer might be.
Sure.
And so to take this step, we appreciate it's often a big step,
Yeah.
and one that has been thought over time and time again. When we initially have that conversation, it's a lot of listening, and it really is a compassionate approach to some of the important questions that are asked, and sometimes it may not always be apparent to the parent.
Sure.
Why we're asking certain questions.
Okay.
And those questions are because there are certain things that we know will need to be answered in a lawsuit, or that will tell us whether there was a problem with the birthing process or the treatment that was given. So there is, like I said, a lot of listening to what the issues are, some questions, and that's one of the reasons it's a good idea, if you can, or if you feel comfortable, to have as much information as possible so that conversation can be as fruitful as possible. During that conversation, there's an explanation about what happens, about what the process is, similar to some of the discussions that we're having today. The collection of the information, what are the red flags in case they weren't sure, and then just a discussion about whether we think that it's worth you asking more questions, delving into it more deeply, what we would suggest that you might want to think about or do. And the important thing, I think, too, is that it is a conversation that is completely confidential.
Okay.
It does not get reported back to any of the medical team, or anybody else for that matter. It is a conversation that you can walk away from, or that you can continue to pursue as the parent, depending on how comfortable you are. And it is one that hopefully educates you a little bit in terms of what you'd be looking at long term if you wanted to pursue something. So I think that's really what you would be looking at in terms of initiating a process or a conversation with a lawyer.
Now, how would they, I guess, first of all, one of the questions would be, is there a cost for making that call? I'm assuming that's just a free call to the law firm for that initial sort of conversation.
That's right.
Okay.
Yeah.
And then how would they know who to call? Right? How to, again, you're in that situation. Who do I call? How do I know how to reach out to someone and make that first step? What should they be looking for?
Well, you really want to speak to a lawyer or law firm that has experience and knowledge in this area of law.
Sure.
Law, litigation is a very complex area these days, and getting more complicated all the time. And there are very specialized areas within litigation. Medical malpractice litigation is a very specific area. Not a lot of lawyers or a lot of litigators practice in that area, and it's the type of area that requires a fair bit of knowledge of the medical issues, of the hospital issues, of obstetrics and neonatology, knowledge of how these cases develop and unfold and how they are presented in court. So you really want a law firm that has experience in this particular area of law. And how do you find a law firm like that? Through word of mouth, through talking to some other people that you may know. 3-2B in the PAL community might be a source of information, as it is a source of information for other resources that families and parents need. Legal resources might be one of those that the information is there to be shared. Or else just in the general community, you can get referrals to a law firm that does this type of work. Or from your own lawyer, you may have had experience with a lawyer in some other area, a real estate lawyer, or a corporate lawyer. Ask them to refer you to a law firm locally that specializes in this type of litigation.
So I mean, I would think, once you sort of have that conversation, you don't want to have that phone call too many times, right? You're telling your story, you're hearing that information. So I think that there would be obviously some value in making sure if you're going to make that phone call, that you're making that good first phone call.
Yeah, that's a good point.
Yeah, okay.
Yeah.
One thing I might suggest as well that I've found to be effective and something that people appreciate is write down in point form a chronology or what your concerns are.
Okay.
And obviously we can receive them by email as well, and that way we can have a look at it while we're having this discussion with you.
Okay.
Because a chronology is always something that's helpful for anybody.
Sure.
And I think a lot of times parents take notes as things occur.
Definitely.
And it's just a helpful way for us to have more information and be able to be more informed to give you the information you need.
Okay. So they've made this phone call, they've had this conversation, they've spoken to, a lawyer on the phone, they've got all of their stuff put together, and they think, okay, they've come away from this call and they're feeling pretty good about it. They're feeling, they tested the waters, they're not as nervous anymore. They feel like there is really somebody on the other end of the line that's listening to them. What do they do now to move that past that phone call, right? What's that sort of next step for those parents or those families that want to move it beyond that and they actually want to start to take some action on something?
Well, at this point, we know whether or not they have the records.
Okay.
But certainly, people's understanding could be different than what's actually in the records. The records tell us a huge story. Okay. There's a huge amount of detail in there that's necessary. And one of the reasons it's important to have a lawyer with experience is we know what to look for.
Right.
So often we either have people send in the records that they have, request them ourselves so that we can have a look at them. Again, there'd be no charge for the time because we're doing that initial answering the question as to whether we think there's anything there. So we look at those records and often are able to get a quick verbal opinion from an expert who can have a look at it and tell us one way or another. After we know that, we can go further. We can go further to actually get them to review the records or give us a more in-depth opinion. And during this entire process, we're very much in touch with the parent.
Okay, so they know what's happening and then who you're talking to and all that sort of thing?
Exactly.
Okay.
Yeah. Okay. So this is still very initial preliminary investigation. Each step of the way, if there's any drawback or hesitation, we express that to the parent. Each step of the way, if there's this is absolutely, there was something that didn't happen the proper way, we can tell that to the parent as well. Another thing that we get often at that stage is that expert who gives the verbal opinion can tell us, look, this and this went wrong, but here and here is a very good explanation for that. So if you do pursue it, this is what you're facing in terms of response. And so again, a lawyer, similar to lawyers like us, will have an ability to weigh those, weigh the pros and the cons to, again, inform the parent as to what the risks going forward might be.
And what's the role of the parent in this sort of initial piece? Again, we've talked about, I have a child with special needs. Your every day is it's tough. There's a lot going on, especially in those early days, right? You're trying to track down appointments and you're trying to keep everything going. And now you've just, potentially pursued this, much larger situation. So what do you expect from the parents in that initial sort of investigation period?
We really don't expect the parents to do that much, and it's not necessary that they do that much. We're doing the work at that stage, and parents and the families really should spend their time and their energies taking care of their child. The investigation is really something that we do. We review the records. We interact with the expert consultants that we use to look into the case,
Right.
and we report back to the parents to tell them what the opinions are so far. But we're not expecting anything more active than that from the parents.
And this is always the magic question, but what does that time frame look like? I mean, how long could that initial investigation take, right? I mean, I imagine there's got to be a lot that you're looking into so that you can, define whether or not this actually is a viable case.
Yeah.
Is that months? Is that, what does that look
I
like?
usually tell parents, just as a rule of thumb, it could take up to 6 months.
Okay.
And it can even take a lot longer if we can't get all the records we need. Sometimes when families come to us many years after the fact, and this is something I might have mentioned earlier, sometimes parts of the records aren't forthcoming immediately from the hospital. Often just for innocent reasons. They can't locate certain pieces of the chart that many years later. And it could be some critical pieces of paper that can't be located, and it takes longer to get them, and then we're waiting for months and months until the hospital can find them. And then once we get that, we can continue the investigation so things can get delayed. It can take sometimes up to a year to finish the investigation process.
So while all of this is going on, and we went back to some of the parents that, that we liaison with, and through 3DB and through PAL, and we asked, what are some of the biggest concerns for you, with respect to sort of investigating a potential situation for your child from a legal perspective. And one of the biggest things that came back is cost. What is this going to cost me? Having a child with special needs can be extraordinarily expensive. They have, a lot of the times parents aren't working, they're home, they've got these expensive therapy appointments and equipment. What is this going to cost them when they enter into this sort of situation?
Yeah, that's obviously a critical question, and something that we discuss pretty quickly after meeting parents. It's on the front of everyone's mind,
Absolutely.
obviously. Lawyers traditionally have charged for the work they do on an hourly rated basis. That just doesn't work in this area of law. It just doesn't happen. And we don't even attempt or even suggest charging hourly rates for the time that we put in. When we take on a case, if we're going to pursue a case, we do it on a contingency fee basis. And we can talk about that a little later, but just for the investigation stage, there are costs associated with that. There are out-of-pocket costs. There's the cost of getting all the medical records, and the parents may have paid for that themselves if they've gotten the records themselves. If we have to do it, then we incur some of those costs. Then there's the costs of the medical consultants that we use, and we may have multiple consultants. In fact, we almost always have to have multiple consultants on a medical case like this. And they are specialists, and they charge for their time. Some charge more, some charge less.
Right.
But even the ones that charge less, they're still charging a lot.
Yeah, for sure.
And that can be a big expense. The cost of thoroughly investigating a case involving labor and delivery and neonatal care, just for the expert expenses, can be many thousands of dollars just to get the preliminary opinions from the specialists that are needed. Some medical malpractice lawyers will suggest and request, if the family can afford to cover those out-of-pocket expenses, that the family provide funds for that or part of the funds for that. But more often, in situations like this involving these types of medical cases and serious neurologic disorders, we understand and we know that families can't afford to provide funds for that. The funds that they have are being used for treatment and care and other purposes that are more important. In most cases, we will pay those expenses ourselves as a law firm. We will pay those disbursements ourselves to investigate the case. We generally, if the case is going to proceed further and become a lawsuit, those are called disbursements that we hopefully will recoup at the end of the case, along with the rest of the disbursements that are incurred later on as part of the settlement.
And I imagine that this is probably part of that conversation with that initial phone call, right? I would think that parents are going to want to know sort of what that fee schedule looks like or what that looks like. So they should have a good understanding of that before they decide to move that beyond that phone call stage.
Either in the first phone call or the first meeting. Yeah.
Okay, so Neil, talk to me a little bit about what it is that you do and how you can help these families.
Well, our firm, Howie Sachs and Henry, is dedicated to helping victims of serious personal injury and their families. And we handle the full spectrum of personal injury cases. But a very significant component of that is medical cases, medical malpractice cases. And a very significant component of that is cases that involve prenatal, labor and delivery, and neonatal care. And we have a lot of experience handling claims and cases for families and their children in that area of medicine. We have a group within our firm that predominantly handles cases of that type, medical malpractice cases, with a very large emphasis on that particular area of medicine.
Okay. So as you can imagine, this is a pretty hot topic of conversation, a lot of questions around it, something that's very, very prevalent in the special needs community. So while we've been talking, there have been a ton of questions that have been coming in. So if it's okay with you, I thought that I could go ahead and ask you some of those questions that have been coming in from the people that are participating. And we certainly encourage people to continue to send in those questions. But I'm just going to pick three right now to go over. So
Sure.
Neil, I think this is one probably for you. So this is a question that's come in, and it says, I'm hesitant to start this process because I really like my doctor. What is going to happen if I sue him?
Yeah, that's a question we get asked a lot. When you sue a doctor, first of all, the doctor has an organization that stands behind him in these situations, him or her, which will provide his legal counsel, and which will also generally pay whatever compensation or damages the doctor is ultimately responsible to pay, if that's what comes to be. The effect on the doctor can also have some professional repercussions, in the sense that an actual finding of medical negligence against a doctor is something that will go on a record and may have to be reported or revealed on subsequent questionnaires, or if changing jurisdictions, or if privileges need to be renewed from time to time at hospitals. It's something that will be there on the record and has to be disclosed.
But, I mean, I would think that that shouldn't be a deterrent for somebody to want to potentially pursue this situation. I mean, it's all about their child and what, you know, that means for that child growing up and the needs they're going to have. And
well, I would agree that you know, there's so much at stake in terms of the future needs for children with disorders and injuries of this level of severity, that it's important to obtain the compensation, I think, if the child is entitled to it.
So Neil, I have another one here, I think probably directed towards you. And the question is, do you only handle cerebral palsy cases or other neurological disorders as well?
Well, in this area, in the medical malpractice cases that we handle relating to labor and delivery, many of the cases involve a diagnosis of cerebral palsy. But there are other types of diagnosis, other conditions that can result, that we've handled, other types of neurologic disorders, brain injuries that do not amount to cerebral palsy, but are otherwise very significant brain injuries. Even metabolic disorders that children suffer from may give rise to a case in connection with the detection and the treatment of those disorders, and whether that was handled successfully or not. So there's a variety of conditions, a variety of very serious conditions and disorders that children suffer from that we've been able to help with.
So the third one here I'm going to take just for the time being. I think, Megan, this is probably going to go towards you. And the question is, what happens if I've already called another personal injury firm and they don't want to take my case?
It's never a bad idea to get a second opinion. What's at stake here is significant. This could be lifelong care. It could be treatment needs. They're huge out-of-pocket expenses that are associated with caring for some of these children for their lifetime, because we're often being called in on this at the very early stages of their life. You don't know for sure why another firm may not be able to assist you. And it could be that they just don't have the expertise in that area. It could be that they've contacted the wrong experts to give the initial opinion. It could be that they don't have the resources to be able to fund a lawsuit. It could be that they know, given some of the risks in the case, that this particular case has a higher than normal likelihood of actually going to trial. And some firms don't have the resources to go to trial, which ours do, or just ours does. So it's always important, I think, to get a second opinion. And we often provide that. In terms of people that have already started a process, part of I think the really important, at least me as a mom, I would find to be a really important factor, is to have a really good trust relationship with your lawyer, to establish a communication that you're happy with, to be as informed as you want to be. And if you find that that's not happening, or that you need further support in that way, we can also provide that. The other thing that we do quite regularly is act as counsel for other firms. So the other firms will actually recommend that we get involved, again, because of our particular area of expertise and the resources that we have available to us. So it's not uncommon for other firms that are actually carrying your case to suggest or recommend that we actually come on board as well. So that's another reason that we often talk to people who've actually begun the process.
I wanted to thank everyone for all the questions that you sent in today. I think they were fantastic questions, and we certainly encourage you to continue to send in those questions. We may not have gotten to them right now, but we will absolutely answer all of those questions that come in offline. I wanted to thank Megan and Neil for being here today. I think it was an extremely informative information session. I know that I learned a lot, and I think the people watching will have learned a lot.
Thank you, Brenda. It was a pleasure.
Thank you.
Thank you. So thanks so much, and we will see you next time.